broadcast with a question today. And the question is justice still blind to the safety of women? Now, this question is based on a controversial order that has been delivered by the Patna High Court. And before I tell you all about what that order is, let me take you back to 2008 to where it all began, to what this case is all about. So back in 2008, in Amarpur in Bihar, a woman, a girl, accompanied by her father, went to a photography studio to get some photographs clicked. And after the photographs were clicked, now this is what the allegation is and the report suggests. Allegedly, the studio owner asked the father of the girl to step out. He bolted the door from inside, forced himself upon her. The prosecution says he attempted to remove her salwar. He physically molested her by pressing her chest. And that's when the girl started screaming. Upon hearing her screams, the father rushed to her rescue. The accused fled. Now, action was taken against the accused. Action was taken by the trial court that convicted that man, that convicted the accused for attempt to rape. But that particular conviction today is at the center of this entire controversy, because 18 years later, now cut to what happened in the Patna High Court. Now let's tell you what happened as far as the Patna High Court is concerned, what the order is and why it's so controversial. So that particular order of the trial court of convicting this accused for attempt to rape was challenged in the Patna High Court. The process began. The High Court re-examined all the evidence, went through all the details and arrived at the conclusion that the prosecution was not able to establish that this was an attempt to rape. And that's not the controversial part of it. The controversial part is the reasoning and the conclusion that the Patna High Court arrived at thereafter. So the Patna High Court accepted the allegations that were leveled by the prosecution. The court accepted that, yes, the accused confined the woman in that studio, that he forced himself on her, that he attempted to remove her salwar, that he physically molested her. But the conclusion that the court arrives at is that this is not sufficient enough to constitute an attempt to rape. In fact, this constitutes to outraging a woman's modesty. Now, the reasoning that has been given by the court is where the problem lies, is where questions are being raised on the implications of what the Patna High Court has said, on the implications of arriving at a conclusion that this is only amounting to outraging the modesty of the woman, and to also in fact go on and say that the prosecution was not able to establish and not enough evidence was presented to prove that penetration happened. There is not enough evidence with the prosecution to establish attempt to rape, and that the prosecution solely has built this case based on what the victim and the victim's father had to say. Questions are being posed on, is that not sufficient? The victim's testimony, is it not sufficient for the courts, for the prosecution to go ahead with the investigation of the case and to arrive at a conclusion based on the testimony of the victim? There are other details coming to fore as well. Now, this is where the controversial part is. The entire issue of the Patna High Court's order was raised in the Supreme Court. It was brought to the attention of the Supreme Court, and at that time, interestingly, the Supreme Court was hearing a suo motu case of a similar controversial order, similar in nature, similar in facts, that was delivered by the Allahabad High Court, and the Allahabad High Court had also given an order on the same lines, that cutting the strings of a victim's pajama and physically molesting her does not amount to attempt to rape. The court pulled up the Patna High Court and said that lack of research is the reason behind it. The judges need to do their research. The staff is not doing anything. And not just that, the Supreme Court also immediately realized that this is not about a particular high court. This is an institutional problem. And after recognizing that the larger institutional problem exists, the Supreme Court also rolled out sweeping measures aimed at changing how sexual offense cases are handled across the justice system in India. Let me in fact go across to my colleague Akanksha, who's joining us in the broadcast with more details. And Akanksha, like the Supreme Court has also realized that this is a larger institutional problem. It's not just limited to one verdict, a particular verdict or a particular high court. We've seen several such controversial orders delivered in the past that fail the victim.
Absolutely, Swati. This is deeply unsettling. Let me take you through the order copy of the Patna High Court. What it mentions, it goes on to say that accused used criminal force against the victim by confining her inside the studio, closing the door, attempting to remove her salwar and physically molesting her by pressing her chest. Goes on to say that such acts were likely to outrage her modesty, thereby satisfying the ingredients of Section 354. Then it also goes on to say, and this is the most important part, that at best, the allegations disclose an act intended to outrage the modesty of the victim, thereby attracting the ingredients of Section 354 that relates to outraging the modesty, and the conviction of the accused under Section 376. Now, this relates to rape. Read with Section 511 IPC, this relates to attempt to rape, does not appear to be sustainable in law. And then the judge goes on to say that prosecution has miserably failed to establish the charges leveled against the accused in this case, and also that above named accused is now acquitted from all the charges that are leveled against him. So imagine reading this as a survivor and being told that whatever happened with you, it was nothing. In fact, it did not amount to attempt to rape, and the person has also been acquitted like nothing happened.
Absolutely. Now, like I said, the Supreme Court has realized that this is a larger institutional problem. The Supreme Court has also approved the National Judicial Agency's report on sensitivity when it comes to such issues, and has said that all the courts and the police stations will refer to this particular handbook when dealing with sensitive cases. Let me in fact go across to my colleagues who are joining us on the broadcast. We have Kritika joining us from New Delhi, Ridita from Kolkata, Varshni from Bengaluru, and Arpita from Trivandrum. I first want to go across to Kritika. Kritika, we have discussed at large such controversial orders, and at the center of this entire issue, at the heart of it, lies one simple question: is justice blind to women's safety? Has it not failed the victims when you have such observations coming in where the court says that cutting the string of the pajama of the victim, or forcing upon themselves, or even physically molesting them does not amount to attempt to rape? It at max or at best, as per these courts, is outraging a woman's modesty.
Well, this is quite a shocker, in fact, as far as the people that we have been speaking to, and I'll get you the voices from some of them. मैम, एक ऐसा ऑर्डर आता है पटना हाई कोर्ट का जिसमें कह रहे हैं कि अगर एक माइनर लड़की का आपने सलवार के स्ट्रिंग्स काट भी दिए, उसको मोलेस्ट भी करने की कोशिश करी, तब भी वो रेप अमाउंट नहीं होगा। आपको क्या लगता है कि ऐसे जजमेंट से विमेन सेफ्टी के लिए आपके खुद के दिमाग में आप इसको कैसे इंटरप्रेट करते हैं?
मेरे हिसाब से तो ये सेफ नहीं है, बिल्कुल सेफ नहीं है। अगर कोई किसी को गलत नज़र से भी देखे ना, तो भी उसे पनिशमेंट मिलनी चाहिए।
जी, और यहाँ पर तो कोर्ट कह रहे हैं कि अगर अटेम्प्ट टू प्रेस किसी माइनर के ब्रेस्ट्स भी हैं, उसको भी आउटरेजिंग मॉडेस्टी कहेंगे, उसको भी रेप नहीं कहा जाएगा।
तो फिर एक ही बात है, उन जज से ही पूछ लो कि अगर बाकी लड़कियों की जगह उनकी खुद की बेटी होगी तो अब क्या कहेंगे? फिर तो एक ही सवाल है ना। पर खुद की बेटी पे बात आएगी तो फिर सजा वो भी खुद ही देंगे जी, और उसे नहीं कहेंगे
जी। सुप्रीम कोर्ट का ये भी कहना है कि ये दिखाता है लैक ऑफ रिसर्च, कि कैसे जज लोग रिसर्च में या उनकी टीम रिसर्च में अभी कम है। आपको क्या लगता है कि इतने बड़े पोजीशन पर होने के बाद भी अगर ऐसे जजमेंट आए तो आप कैसे इसको इंटरप्रेट करें?
फिर तो खुद ही जाके पनिशमेंट देनी पड़ेगी। मैं अगर सच बताती हूँ, अगर मैं किसी और की जिसके साथ ऐसा हुआ हो, अगर उसकी जगह मैं खुद रहूँगी ना, तो मैं खुद के सपोर्ट में खुद ही खड़ी रह जाऊंगी। मुझे दूसरे का सहारा नहीं चाहिए।
So this is the situation as far as these orders are concerned. What we've also been speaking to more people around us as well. They've been telling us that such orders really sort of erodes their
based
trust
on that interaction that you just had, Kritika, it raises a very important question. Are women now supposed to, stand for themselves and completely lose hope in the judicial system? Should they lose hope that anyone will ever come to their rescue? That's what it implies when you hear those reactions that you are getting us live from people who have been outraged, who've been shocked upon hearing about this particular development. We've also opened our phone lines. Our viewers are calling us. Let me go across to Brigadier Sanjay Khanna joining us from Greater Noida. Thank you very much for joining us. What are your views, sir?
It's actually a very, very shameful decision given by the honorable judge. In fact, I don't know why do we even use the word honorable, because the decisions that are coming out are absolutely dishonorable. why did the gentleman lock up the room in the first place? He had an ulterior motive. Now, what was the ulterior motive? To outrage the modesty? After outraging the modesty, what would have he done? He would have raped her. Otherwise, there was no question of him bolting the door and then molesting her. But why don't the judges understand?
You're raising a very important. You are raising a very important point. If it not had been for the father who heard the screams and came to the daughter's rescue, what would have happened? Thank you very much for speaking with us, sir. We also have AP Singh, Senior Advocate, Supreme Court, joining us on the broadcast. Mr. Singh, your first comment on what the Patna High Court has said, that this does not constitute attempt to rape.
Actually, the order of the Honorable High Court of Bihar at Patna, they want to pass order with the landmark judgment for categorical punishment. His interest was only to categorical punishment, but Honorable Supreme Court of India given overview to protect the modesty of women in our country. Protection of women should seen a great, not only on the official statement. If we see official statement of the central government as well as government of state, Beti Bachao, Beti Padhao, that is not sufficient. We should come on the ground zero. Criminal FIR and incident of outrage are in our country day to day increasing in our society. Even police officers are adopted, women commission, women helpline, PCR, women control room, etc., each and everything available. But still now we are suffering. The point is that a shameful pattern. Judge must also do some research. Who will responsible? ये innocent.
नहीं, जो आप कह रहे हैं, जो आपने कहा, यही सुप्रीम कोर्ट ने भी कहा कि जजेस को भी खुद रिसर्च करनी चाहिए, स्टाफ के भरोसे नहीं होना चाहिए, स्टाफ कुछ नहीं कर रहा है। लेकिन मेरा सवाल आपसे, जो रीजनिंग दी गई है उस पर, और जो हमारे अभी एक दर्शक ने बात कही एपी सिंह जी, मेरा सवाल उस पर है। दरवाजे को अंदर से बंद कर लेना, विक्टिम का सलवार निकालने की कोशिश करना, उसको फिजिकली मोलेस्ट करना और तब तक नहीं रुकना जब तक कि उसका पिता वहां उसे बचाने के लिए नहीं आ गया। आपके हिसाब से अगला क्या करने का इरादा था? इससे साफ इंटेंशन कैसे पता चलेगा? इससे ज्यादा कोई क्या कहे उस अक्यूज्ड के इंटेंशन के बारे में?
आईपीसी की जो 354 सेक्शन है वो पब्लिक प्लेस को बताती है। पब्लिक प्लेस पे अगर आपके साथ ऐसा होता, समझिए आप, पब्लिक प्लेस में टच हो गया, पब्लिक प्लेस में प्रेस हो गया, पब्लिक प्लेस में ब्रश चेस्ट या इस पर अटैक हो गया, पब्लिक प्लेस इज डिफरेंट। यहाँ बोल्टेड किया गया, स्टूडियो में गई इंटेंशनली प्लान के साथ विद द ग्रेपिंग ब्रूटल ऑफेंस। पॉइंट इज दैट it is not a natural offense. Natural offense means if you are going to public place, आप कहीं बाजार में जा रहे हैं, सड़क में जा रहे हैं, रास्ते में जा रहे हैं, धक्का लग गया, छेड़खानी हो गई, आई टीजिंग हो गई, तो वो इंटेंशन नहीं थी, प्लान नहीं था। आप स्टूडियो चला रहे हैं, आप ऐसा अक्सर लोगों के साथ करते रहे होंगे। ये तो बेटी का पिता आ गया, ये बेटी अलर्ट थी, जागरूक थी, स्टूडियो आपने बनाया।
बिफोर आई गो अक्रॉस टू अदर रिपोर्टर्स, एपी सिंह जी, क्या ये गलत संदेश नहीं भेजता है? क्या ये गलत संदेश नहीं भेजता है? विक्टिम्स को अगर कोर्ट से इस तरह की बात सुननी पड़ेगी तो फिर वो कहां जाएंगे?
उनके पास कोई रास्ता नहीं बना। एक दर्शक ने कहा ऑनरेबल मतलब सम्मानजनक। मैं भी सम्मान करूं, आप भी सम्मान करें। इस देश के गुवाहाटी से चौपाटी, कन्याकुमारी से कश्मीर, कटक से कटक, खाड़ी से पहाड़ी तक के लोग सम्मान करें, तब वो सम्मान है। दैट इज द ट्रू रिस्पेक्ट to the honorable court. We are saying honorable court. What is the doesn't mean the honorable court. तो ये डोर बोल्ट करना, अंदर कमरा बंद करना, मेलाफाइड इंटेंशन होना, प्लान ऑफ क्राइम, इंटेंशन ऑफ क्राइम, प्लान ऑफ क्राइम,
और हर किसी को, चाहे वो कानून समझता हो या कानून ना समझता हो, हर किसी को ये सीक्वेंस ऑफ इवेंट्स जानने के बाद ये समझ आ रहा है कि इंटेंशन मंशा उस व्यक्ति की क्या थी। उसके बावजूद ये कहना दैट दिस डज नॉट कॉन्स्टिट्यूट अटेम्प्ट टू रेप, इसीलिए सवाल उठ रहे हैं कि न्याय दिलाने का काम जिस व्यवस्था का है, अगर वो इस तरह की बात कहेगी तो फिर विक्टिम्स कहां जाएंगे? मिस्टर सिंह, डू स्टे ऑन विद अस. लेट मी गो अक्रॉस टू माय कलीग्स. Arpita is also with us on the broadcast. Arpita, this has outraged people across the country, especially women who are asking, where else will they go asking for justice if these are the kind of observations and orders that are going to be passed?
Well, yes, Swati, I'm here at Maharaja's College in Kochi, which is a very famous college, and I'm being joined by a few of the female students here. Like I mentioned, there was a observation made by Patna High Court that trying to remove a women's salwar does not mean that it is a rape. So what do you have to say on that statement?
I'm totally against that statement because in such a situation, we all know our body is our private thing. So violating our personal boundaries without our permission, without our consent may have serious consequences. So touching a person without their permission is assault. Whatever it is, like intentionally or not intentionally, touching us without our permission is assault for sure. So in such a situation, I don't know how a court is being said such a statement. As we all know, at certain situations, we are seeking our justice from the court, and such a court is giving such a statement about a women and their clothing and everything. So that is really utterly, I think it's so bad.
Well, Swati, like you mentioned, even she's pointing out the same thing. A court where we go for justice, if
Absolutely.
that same court is giving such statements, then that is definitely questionable and it is really shocking.
Absolutely. Arpita, do stay on with us. We have Ridhita and Varshni on the broadcast as well. Let me go across to Ridhita first. Ridhita, are you also speaking to women around you? What is the kind of reaction that you're getting?
Well, absolutely. You see that I'm standing here outside the Presidency College, which is one of the famous college. And however, here we are seeing that this hour is of the college getting over. We are here seeing parents out here. We just speak to one of the parents. Sir, in Patna High Court today, we have seen that the order that has come out against a girl who has been raped, stating that if a girl is forcefully tried to be removed her salwar or her chest is pressed, then it is not an attempt to rape. That is what the justice herself has given the order. How do you react to this entire situation? What do you think of it?
No, it is depend on the condition. In what condition it happens, or matlab, may I talk in Bengali?
You can talk in Hindi also.
Oh, okay. ना अगर देखते हैं सिचुएशन क्या है, अगर उस पर मतलब जो जोर करके कर रहा है, जबरदस्ती हो रहा है, तो सब कुछ ही एबनॉर्मल है और वो मैंने क्या है उसको जबरदस्ती हो रहा है.
Ma'am, don't you think pressing a chest of a woman is an attempt to rape, because that gets ruled out again? Is that, are we living in a civilized society where you think the courts are raising question on women now?
Yes, certainly. But मैं बोल रही हूँ ना, कंडीशन के ऊपर भी निर्भर करता है ना कि किस कंडीशन में ये हो रहा है. अगर एक पेशेंट है उस पर ये हो रहा है तो जबरदस्ती नहीं है, लेकिन अगर आप किसी को कुछ हासिल करने के लिए जबरदस्ती कर रहे हो तो जरूर अटेम्प्ट टू रेप है.
So you see, we have been speaking to one of the parents out
जबरदस्ती अगर
here
आप
saying
कर
that
रहे
it
हो,
again gives
if you're forcing yourself on someone, it's wrong. And like I said, you know, even if people don't understand law, they understand the basic intention of this individual, the accused, and what he was trying to do. So why can't the learned people arrive at a conclusion that his intentions right from the start were attempt to rape? Let me go across to Varshni, who's joining us as well on the broadcast. Varshni, do you have people around you? What are the kind of reactions that you're getting?
Well, absolutely, yes. So we do have some women around us who are aware of what these kind of, ruling have come from the Patna High Court. In fact, they are furious because, Bangalore, a city where women, all youngsters come around here to know and have a life for themselves, and listening to such things, they are definitely terrified. Let's try and get in some word. Hi, are you aware of the Patna High Court ruling yesterday where they mentioned that, touching a breast does not account to rape? As a woman living in India, how do you feel at this point? What do you have to say?
As a woman of India, I don't feel quite comfortable with the law it was given. As a public figure, isn't it their duty to look into every citizen's point of view and then give the ruling? If this law is really right, why don't I go to a random person on the street and start abusing them? Meaning, I didn't hit them, it wasn't violence. Please tell me why this law is different from that law. If that is correct, this is also, I feel it is quite right.
What would you have to say about it?
It's like touching a woman is like not a violence. It's not a appropriate answer, I think so, because even I touch a man who is, I don't know them. If I touch them, it doesn't mean like they don't complain, but we don't do it. But as women, I feel uncomfortable, which is not a proper thing.
So are you trying to say that women's sensitivities here, what women feel is not taken enough into consideration while such statements are being made by the high courts of the country?
Right.
Yes, obviously there is a difference between an obsessor making a law and the oppressed making laws. If we also are equal citizens in the India, we should also have...
All right. So I think the basic sentiment is that people are finding it extremely difficult to wrap their head around this order, to make sense of this order. We have Geeta joining us from Mysuru, a viewer. Thank you very much, Geeta. Good afternoon. What are your views? Go ahead.
नहीं, मुझे बोलना है कि ये जुडिशियरी थोड़ा तो चेंज करना है. कभी भी देखो वो कल्प्रिट को जस्टिस मिलता है, हमें कुछ नहीं मिलता. लेडीज मतलब उसको टेकन फॉर ग्रांटेड वो हो जाता है. ये नहीं होना चाहिए ना.
बिल्कुल सही कह रही हैं आप कह रही हैं कि टेकन फॉर ग्रांटेड लिया जा रहा है महिलाओं की सेफ्टी को. Thank you very much, Geeta, for speaking with us. AP Singh continues to be with us on the broadcast. AP Singh, like I said, there's just one sentiment on ground. Whether you understand law or you don't understand law, whether you understand these sections and the nitty-gritties and the legal procedure in court or not, one thing that everybody understands is that the intention of this accused was clear. वो क्या करना चाहता था, उसकी मंशा साफ है, स्पष्ट है. और एक और चीज जो कॉमन है, जो भी रिएक्शंस हमने सुने, लोगों को ये समझ नहीं आ रहा है कि ये ऑर्डर दिया कैसे गया, इस ऑर्डर तक अराइव कैसे, हाउ डिड द जज अराइव एट दिस कंक्लूजन, और जो रीजनिंग दी गई है वो भी लोगों के समझ में नहीं आ रही है.
The important point is the role of the trial court, the role of the appellant court, which is available as well as Honorable High Court of Patna. The role of the appellant, second appellant court is as well as Honorable Supreme Court of India. In cases of like this type, cases related the women, related cases the girls, most of the cases, victim, prosecutrix, at the time of when she produced before the statement of 164 and CRPC and 161 CRPC for the statement recording before the police officer, before the magistrate, at that time she could not explain each and everything because she is not a habitual complainant. She was not a habitual professional in this regard. She was not legal expert. So in these cases, most of the cases, in the most of the prosecutrix, most of the victim, at the time of her recording of her statement, shy, do not explain each and everything. The intention of the photographer, the intention of the owner of the studio is very much malafide, very much malafide. He used his own studio office for this purpose. Public place is different. It's a private place.
And there's one question that comes to mind, that, what if the father was not present there? What if the father did not rush to his daughter's rescue? What would have happened then? One,
yes,
the other thing that you were talking about, the statement. Yes, the statement of the victims. Now, in this particular case, the court says, sir, the prosecution rested on the testimonies of the survivor and her parents. So, if that is also not enough, then what else needs to be produced before the court to convince them?
Survivor is a father, natural father, eyewitness. He reached at the place. What happened with his daughter? What is he feel with his daughter? How can he? The statement is very important. A person went to for his snaps, photograph, taken a photograph, passport size, are different type, official. And when he or she reached, when a girl reached for getting her photographs, then how can she imagine a photographer can disturb the modesty of a girl, of a customer? She was her customer. She came.
And it's not about the profession of the individual. It's not about the profession of the individual. It's about the act. It's about the intention of the accused. And the question remains, if the father was not present there, if he would not have intervened, come to the rescue of his daughter, what would have transpired? And despite, all of this in public domain, the court arrived at a conclusion passed an order saying that this does not amount to attempt to rape. All that the court believes or sees is outraging a woman's modesty. This has sparked a massive debate now. There's outrage across the country. Women are asking, where else are they supposed to go seek justice if these are the kind of orders that are going to be passed? Thank you very much, AP Singh, and to my colleagues for getting us those reactions, to the viewers as well for calling us and for expressing their views on the broadcast. Quick break.